Hey, good afternoon. Thank you all for coming to Humanities Decanted, the IHC's informal showcase in which faculty members present and discuss their newest research and creative work. My name is Susan Derwin, and I am the IHC Director, and it's my pleasure to welcome you all here today. Before we begin, I would like to acknowledge the Chumash people, who are the traditional custodians of the land upon which the Interdisciplinary Humanities Center is located, and I would like to pay respect to elders, past and present. I am delighted to welcome Giuliana Perrone and Jeannine DeLombard to the IHC to talk about Professor Perrone's brand new book, Nothing More Than Freedom, The Failure of Abolition in American Law, which just appeared last week with Cambridge University Press. Giuliana Perrone is an assistant professor in the history department, where she teaches and researches on the history of slavery and race in North America, American socio-legal history, the history of the Civil War and Reconstruction, and the development of American political legal institutions. Jeannine DeLombard is a professor of English and an affiliate of the history department. She works on African American and pre-1900 American literature, and she has a particular interest in the intersections of slavery, law, and culture. So after a short presentation by Professor Perrone, she and Professor DeLombard will converse with one another for about 30 minutes, and then we'll open up the discussion to you, our audience members, so that you can ask questions and share your thoughts. We're going to start right now with Professor Perrone's presentation. Enjoy. Thank you.
Thank you so much for coming. It's kind of surreal that it's done, this book that has been started as a dissertation. I don't really like to count the number of years that I've been working on this project. And I just, the book was an accident. This is not how I started my academic career. I was a 20th century U.S. historian, and I needed a seminar paper. And I found sources that were about slavery, legal cases that were about slavery, but they were decided after the end of the Civil War. And I thought that was weird. And when I went into my advisor's office and I was like, I don't understand what these are, why do these exist was basically my question. And she's like, I don't know, you tell me. I'm working on it. That's sort of been, that's really where it began, and a very frank conversation about how there were more jobs in 19th century American history than there were in 20th century when I was going to be going on the market, and so hard decisions were made, and I decided that I would take up these cases about slavery that were decided after slavery was supposed to have been eliminated. And since that time, it's gone through many other iterations, because as I was deep in the writing process of the dissertation, we saw an increasing public awareness of racial violence in Ferguson, in Florida, in just about everywhere. And so as I have been writing, Black Lives Matter and social justice movements have gone along with me. And in fact, this final version of the book was inspired by a recommendation, really. My series editor, Sally Gordon, recommended that I read a law review article from the Harvard Law Review Forward about abolition as a movement and how lawyers were interacting with abolition as a movement, as a modern movement, and whether or not history could, and legal history, could answer questions or move that conversation forward. And she recommended it to me the day before the murder of George Floyd. And here we all were in quarantine with this sort of swirling around, and I'm sitting here reading this article, and everything, like that was it. Like the whole book was out the door. I had to start over, and I say start over, but it wasn't really right. But the whole framing of the book, I had to start over, and it had to matter I felt there is a debate in the historical profession about how presentist one should be, and I'm very firmly on the side of, if your work speaks to things that occur in the present very obviously, don't shy away from that, embrace that, which is what this book ultimately did. So it is to speak to the abolitionist movement and modern abolitionism, which is very focused on defects in criminal law, the prison industrial complex. And my suggestion, my bit of encouragement is, don't stop there. It's also in these other quieter, smaller spaces of private law that we don't think are still related to slavery. And that's where it is strongest and most insidious. So I hope in some small way it contributes to that broader conversation. And for all of you graduate students, don't worry about the last minute recommendation. You can change things real fast, I promise. And I think I'll leave it there and let Jeannine ask away.
Well, thanks a lot. And I've been madly reading the book over the past few days because, as we said, it just became physically an object in the past week or so. So I'm very grateful to have it. And I've been having conversations with Giuliana about this book for quite a long time. So it's really exciting to see how it actually ended up. And it's a real accomplishment. And I wanted to thank Susan and the IHC for having us, Chris for doing all the organization. I should flag our Slavery, Captivity, and the Meaning of Freedom research focus group that's out of the IHC, and that's actually how Giuliana and I mostly got to know each other. Rose McLean started it, so definitely come join us. You'll see our events on the IHC website and in publicity if we get our acts together in time. So I'm going to pose a question that I'll pose it to Giuliana, but as I'm asking it, I actually want people to think about the answer in your own minds. So if I ask you, when did slavery end? Think about the answer that comes to your mind, either a date or an event. You know, when did slavery end? Or how did it become illegal? And I'm going to throw that to Giuliana because I know it's a trick question.
I mean, the short answer is it didn't. Right? It didn't actually end. It morphed into other forms and other structures, other processes. Historians are very good at tracing the shift from slavery to the rise of the carceral state, for example, again, linking to modern abolitionists who are still fighting against that. I like to make the distinction between slavery as an institution and enslavement as a property relationship. So enslavement ends, right? The ownership of one human being by another, right? The slave as property, right? That part ends. That relationship ends. And when it ends depends on where you are in 1865. But for everybody, finally, with the 13th Amendment. But the 13th Amendment simply ends that property relationship. There are scholars who fiercely contest that and say that it should have been interpreted much more capaciously, but it wasn't. So the slavery part, all that institutional trappings, the part that you have to undo and get rid of and remove away, we're still working on it. And sometimes with more energy and dedication than at other times.
I think that's helpful. And I think it's helpful to think about, when you talked about that moment with your advisor where you were, you said, how come I'm seeing so many cases about slavery after the end of slavery, after the 13th Amendment, after 1865, and, you're told to go research that, and that becomes in some ways this book. But as you point out, you suggest that to know when slavery ended, we need to know how legally it ended. And that puts you on this project of looking at, I can't remember, is it 800 cases?
700.
Sorry, I did not mean to inflate it. 700 is plenty. Yeah, so 700 cases from state courts, from appellate courts, right? So the highest court in each state. And then at the end, you look at the Supreme Courts. You see this process sort of building from the state courts, and then a lot of the questions being finally adjudicated in the Supreme Court. And what we think of as landmark cases. So the civil rights cases in 1883, Cruikshank, before that, I'm bad at dates, you're the historian.
1875.
1875, some lesser known cases, Texas v. White, but also, of course, Plessy v. Ferguson, right? So you have this momentum in the book. And there's a couple of things I wanted to ask you to think about with this, or ask you sort of how you were thinking about it, because I think Giuliana makes a really nice point in this book, which is that we think about this promise of Reconstruction with the Reconstruction amendments. We think about the 13th Amendment abolishing slavery, the 14th Amendment establishing birthright citizenship for all people under the jurisdiction of the U.S., right? That not just, formerly enslaved people, not just African American, defined citizenship for the first time in the U.S. Constitution. And the 15th Amendment not limiting slavery, not limiting suffrage on the basis of race or previous condition of servitude. But as you point out, and I think this is a really important part of the book, is that we think that these Reconstruction, they are such an achievement, that so many people have worked on them, they've debated them, all of that, and we try, whether you believe in sort of looking at the intent of the legislators, the radical Republicans in Congress during Reconstruction. But Giuliana makes this really interesting point that we can debate all of that as much as we want to. What was the intent? What does the text say? What does the context say at the time? But actually, a lot of what it means to end slavery and to establish, or to try to end slavery, and to establish citizenship in the U.S., a U.S. citizenship, really comes down jurisdiction by jurisdiction, and especially to these state courts, right? So can you sort of elaborate on that aspect of it?
Sure. So this idea that you can have birthright citizenship, that the Civil Rights Act of 1866 and then the 14th Amendment imbues people with citizenship and the rights of legal personhood, and that's somehow going to obliterate the slave past, right? That this is going to give formerly enslaved people all the tools they need to be equal citizens in the United States. And what I came to find was, well, that's just not the case, because formerly enslaved people were formerly enslaved. They had lives that were governed by their status. And all of in the book in particular, I focus on intimate relationships, marriages, custody, things like this, that formed during slavery, while none of them had any legal legitimacy. So what happens now, you have all of these rights, but it's not clear when that marriage became legal, or whether or not you have custody of those children and they're actually legally your dependents or not, because those family relationships formed while no such family relationships could form under the law. So I think the part for me that was really important was teasing out all of the ways that granting citizenship didn't remove the stains or the markers of former servitude. You can be a citizen and be an emancipated person and still live with ongoing burdens from your previous condition. That citizenship doesn't just get rid of those things.
And I think one of the examples that you give in the book, and I was going to ask you to talk about this a little bit, is this 1867. So 2 years after the 13th Amendment, 2 years after the formal abolition of slavery, we have this 1867 inheritance dispute between, there's a man, his name is Daniel Allen, and he had been enslaved, and he becomes a property owner, landed estate. I mean, he has his own real estate, right? And we have, and you introduce us to this, as when we come into it, you don't give us a ton of information at the beginning, and then you fill out the information, and that's a little bit what I'm hoping you'll do here. We'll still not buy the book, I promise, because it's a good story. It's an interesting story, I think, that brings out some of these issues. But, we have this dispute between, so this man dies, Daniel Allen dies, and his wife, Jane, gets into a legal dispute with his mother, the deceased man's mother, Fanny Whitesides, and I'm super curious if that's related to other Whitesides cases, but we'll leave that to a conversation with us separately. And I'm wondering if you can talk about that case and talk about how this and other cases involving family disputes, how they can tell us about how some African Americans at this time period negotiated between enslaved pasts and their own plans for the future, both individually and collectively as families.
Great question. So part of this is what you're sort of getting at here is freed people didn't necessarily imagine their freedom or citizenship in the same way that the federal government imagined freedom and citizenship, and what it meant to be, able to make your own choices as a formerly enslaved person might be shaped by any number of factors coming out of the past enslavement. So this particular case is from Kentucky, and Daniel Allen was able to purchase property near Lexington, Kentucky. He had been a soldier in the military, served in the Union Army, and so he uses his soldier's pay to buy this property. And he has a wife, and he has children, and he has his mother, and also other family members, brothers and sisters, and they all live on this property together. And we find out that there's a sort of spoken, maybe, arrangement where everybody's going to live and enjoy the property and the security that that property affords together, and that there's a sort of communal approach to improving it. So the brothers are building some of the new structures and participating in improving both for the quality of life for the people living there, but also increasing the value of that property. And he dies, Daniel Allen, who is the sole property owner, because he's the one that bought it, right? He's the one that signed the deal. He died, and he didn't leave a will. And then we find out that he also didn't get married after slavery ended. And in Kentucky, this was required. Not in all states, but in Kentucky and some others, you had to go and register your marriage. If you had been formerly enslaved and you wished to remain a married couple, you had to go to a local official and register that marriage and pay money to do that. You had to pay a fee in Kentucky, which is, I think, the only place that required that. And they didn't do that. And so here is Jane Allen saying this property should be inherited by our children as the rightful heirs of their father. And the extended family members, mom and the brothers and sisters, half-brothers, said, no. We have a right to this. He promised this to us. And in fact, at one point, they run the children out off the property. And what's really interesting, and this is a question I cannot answer, is whether or not the family, the white side of the family, knew the arguments that their lawyers were making on their behalf. And they basically argue, well, this is exactly why you can't allow inheritance, right? These are bastard children. This is how formerly enslaved people are going to learn how to be in proper families. So you can't allow this kind of behavior, or else you're going to have this sort of depraved social circumstances where nobody's in proper marriages, nobody's in proper households, and the whole society is going to fall apart. So think about this as instructional. You have to side with us. We are the only rightful family. We're the only actual claimants who have a right to this property, because they're all illegitimate. And they talk about him as the reputed father, or purported father, I think is what it was. Like, maybe he's not even really their father. And there was all kinds of scandalous testimony about, well, maybe one of those children was born while he was away fighting. And so there's all kinds of ways to undermine these children's claim to their father's property. And the court does something really, I think, kind of interesting. They do side with the children and also declare them bastards at the same time. Well, sort of. They say that, well, in fact, that marriage is not valid because they didn't go and follow the statute. right? That as a couple, they did not go register that marriage. But there was this other law that said, but we aren't going to hold that against the children. And if they had gone and done that, those children would have been legitimate. And so the court decided they would still see the children as legitimate, which actually makes the most sense. It is the most in keeping with legal traditions that existed before that time. Pass it to the children. But what you're left with then is a whole portion of family members, a community of people who are now out away, right, sent away from property, have no claim to this. We don't know what happens to them.
And it's an interesting example, and I should say, you're probably, when you're using a word like bastard, is that the language that you see in the court?
It is the law of bastardy. That is their word, not mine. I say that, you know what? I say that in lectures every time. I'm surprised it didn't just pop out sort of automatically. But yes, that is the language of the day. Thank you.
Mm-hmm. And it's interesting, right? Because, just to think about that example, and I've been a little bit more immersed in that story that you all have, most of you probably just heard it for the first time. I know Chris has heard it before. And maybe Giuliana's parents as well have heard that story. But it's interesting, right? Because if you think about it, that if you want to make the argument that the family, right, that the sort of, if we want to say the extended family, the mom, the brothers, the stepbrothers, they are playing this kind of politics of respectability card, right? Saying that these are perhaps illegitimate children, that the marriage is not legal, and all of that. But interestingly, they're doing that. They're making that play on behalf of a fairly unconventional family organization, as opposed to the kind of what we would call nuclear family with the mother and the father and the children, right? So they're kind of playing both sides against the middle, or
right. Well,
strategic.
The way that I came to understand this was very much with the help of scholar Dylan Penningroth, right, who talks about what he calls the claims of kinship and the development of non-traditional or non-normative forms of kin relationships within enslaved communities, because the fragility of domestic relationships was endemic, right? Nuclear families couldn't form and have any sort of security, but other kinds of kinship networks became the basis for family ties, and blood relationship was not necessarily a prerequisite for that. And that, I think, is what the mom and siblings were appealing to, is this other kind of kinship that they considered to be the only legitimate one, that they were entitled to that property, that it was for the family.
And then actually, it's interesting you bring up Dylan Penningroth's book, The Claims of Kinfolk, and I think it got one of those MacArthur Genius Awards back in the day, right? Yours is coming. But you cite him, and you cite other people who, when they work on, he's not really not as much a sort of legal historian, perhaps in the same sense, but there are people who, when they work on some of these kinds of cases, they foreground, in Kimberly Welch's word, the historian Kimberly Welch's word, the experience of black litigants, right? So they try to reconstruct as much as possible, the perspectives, the context, the words of the black people involved in a lot of these disputes. A lot of the disputes you look at, we've talked about ones with black litigants, but you're often looking at ones also with white, most all entirely white people. For example, someone buys an enslaved person from another person, and the war happens, and we have emancipation, and then what happens if there's still money owed, right? What happens if there's a warranty on that, the value of that person, right? And so these are a lot of the cases that Giuliana looks at, and maybe you can come back to those. But one of the questions that I wanted to ask, and I wonder, thinking about this in terms of writing the book, is that choice, right? Which is, we have this moment where a lot of people are really interested in black litigants and trying to reconstruct the lives and the worlds of Daniel Allen and his mother, Whitesides, and Fanny Whitesides, and his wife, and all of that. But you begin this book by looking at judges, right? You begin this book by looking at not always Southern judges, but judges in the South. Some of them are from the North, right? But you're really interested in that perspective. And I wonder if you could talk a little bit about why these are white men, right? Why that perspective is an important one for us to think about in the context of the failure, what you're calling the failure of abolition.
I really resisted this. I did not want to center white judges in this story. And in fact, chapters used to be a lot longer because I spent so much time unearthing as much as I possibly could about Black litigants. And I joke, social history is big at Berkeley. And so that was like the thing. I felt like I had to do this. And it finally became clear that the focus of the book were the problems, were the legal questions. And whether or not abolition was going to happen or not was the decision of the judge. And I wanted to highlight how contingent that was, that sometimes just a single judge on a panel could be the difference between doing something that we would judge as, we ourselves would assess as more in keeping with our understanding of eradicating slavery, of achieving abolition, versus those tribunals that just could not imagine a world without the rules that had governed society with slavery for so long. You mentioned that most of the cases are between white people. Yeah, because most of these cases are about contracts. I don't want to know as much as I know about 19th century contracts. I did not, in fact, the whole first chapter, I sort of threw up my hands and stomped around the house a bunch because, and Chris can attest to this, because I did not want to write it. I did not want to write a chapter about contract doctrine. And there I found myself, because the question about contract doctrine was really a question of whether or not you're going to continue enforcing agreements for human property after, supposedly, that property doesn't exist anymore. And you are not supposed to have slavery, right? If the 13th Amendment says no more slavery, then how can you have the instruments of slavery still being upheld by courts? And so that debate was very illuminating and instructive to me. And there I found myself with those judges I did not want to write about, because it was the problem that was the key to the story. And I'll tell you, who really pointed that out to me was our mutual friend, Brian Wagner, who is in the English department at Berkeley. And I couldn't figure out how to organize anything. This is as a dissertation. He's like, well, stop doing what you're doing and think about, well, what are the problems, right? What are the, I can sort of organize all these cases into groups by their problem. And once I did that, I could see how even in suits where emancipated people don't factor in at all, at least they're not present. I mean, they're very much there, but they're certainly not a part of the conversation. They're not going to gain or lose anything based on the outcome, at least not in the short term. But a decision about whether or not to eradicate slavery fully was on the table in every one of those cases.
And I think that's something that's really interesting about the book, right? Because we think of abolition, and we tend to conflate abolition and emancipation. But when you give an example of something really quite as dry, right, as you said, is contracts, right? It becomes this question of, well, if slavery is over, does that mean that contracts involving enslaved people just should kind of poof, not matter anymore? Or is there a contract law that we really need to hang on to for capitalism in the US and to understand how business and to have the stability of business at a deeply unstable time, right? Do we maintain that and not worry that do we enforce those contracts and not worry that some of those contracts are about this thing that has been abolished and now actually about enslaved people, right? And I think that's the tension that you really bring out quite well in the book, the way in which, a lot of us are very aware of the way that the fact that that the United States grew up and developed its law completely in the context of slavery in the North as well as in the South, that we know that it's completely embedded in our law and culture, the 1619 Project, all of that. But you, I think, do a good job of just tracking all of those tendrils, the way that it's just completely embedded. I don't know if tendrils are embedded, but anyway, the way it's completely embedded in our culture, and that you can't just sort of end slavery, but there's all these other legal manifestations that are just completely built into our culture and our law.
Maybe it's helpful if I actually lay out the two positions. So, as you're saying here, right, the contract is the thing in the 19th century. This is this freedom of contract that as long as you and some other person agree to it, it's a valid contract, is what animates doctrine in the 19th century. It doesn't have to be fair. You just have to have agreed to it, and it had to have been, legal to do that in that time. And those who are going to enforce and insist on enforcing agreements for enslaved property will say, well, there is a contract clause in the Constitution that says that the federal government cannot abridge the right to contract, and that supersedes everything else. And state constitutions have the same kinds of provisions, and those contracts were legal when they were made because slavery was still legal when they were made, and therefore you just have to keep paying. Seems like it's straightforward. And the more abolitionist version of this is, that's not abolition, right? If the 13th Amendment actually means that slavery is over, then the instrument of slavery's exchange, right, that what makes slavery valuable, the ability to buy and sell enslaved people, also has to be null and void, that we cannot continue to uphold these contracts. And they're very specific. They're not trying to say that any contract could face this future, but only these, because the thing being conveyed in them is no longer considered a thing, and it is just an extension of slavery's economy, and therefore the 13th Amendment makes them unenforceable. And the judges who hang on to these things cannot imagine not enforcing them. So would be like the modern example. Okay, you have a car and you're buying it, you took out a loan, you're paying in installments your car payment, you wreck the car. The car dealership's going to want its money and going to continue to, you might make a deal for a lesser amount or something like that, but you're still going to have to pay. And lawyers have told me this before. Well, it's like the car that you wreck that you still owe money on. And I said, yeah, but there was no constitutional amendment that said you can't own cars that intervened, right? It's this intervention, it's the radical promise of actual abolition that some judges are able to recognize, but a slim majority will not tolerate, because it is a threat to this economic stability, this sort of bedrock of law and economy. I'm
not quite sure. Susan, where are we with time? Okay, so I'll follow up and ask the question, which is, and I know you're obviously, as soon as one is finished with one book, you're thinking about the next book, but when I've read parts of this where, some of the things that I've read, versions of this, didn't make it into the book. And so when you said, you didn't want to focus on these white male judges, right? You wanted you had done all this research. Can you tell us one of the stories that didn't make it into the book that you're either thinking about for a future book or you're thinking about for a future article? Just, maybe especially the stories from those perspectives of enslaved people.
Yes. So, as you know, I had this whole stash of cases. They were related to wills, inheritance cases, that were very tantalizing, but also I sort of didn't know what to do with them. that involved formerly enslaved people suing the families of their enslavers for stuff. Land, money, education. And I didn't know what to do with them until I saw a call for conference papers for a conference on reparations. It's like, now that's interesting, because these are formerly enslaved. Well, and I had read Caleb McDaniel's book that talks about Henrietta Woods, who sues for her wrongful enslavement and is compensated, and he talks about this as reparations, right? And I thought, well, maybe there's more of this than we have thought about before. And so here are these formerly enslaved people who sue, and some of them, it comes out over the course of litigation, are the illegitimate children of the enslaver. And their white families are really not wanting those illegitimate children to have the estate of the master, right? The planter. And that this is the horror that slavery has that emancipation has unleashed. Instead of following the rules of slavery, now these people, right? These people who are not, in the minds of many Southerners, equal human beings, right? Have legitimate claim to the estates and the wealth of white enslavers. Like, that's not supposed to happen. That's not how this system was organized. And yet, in this moment, it becomes much, much easier, because they have legal standing, right, for formerly enslaved people to sue for this. We know that there were suits over these kinds of wills prior to this, but they were effectively freedom suits, because all of these wills had a provision for manumission and then also this other stuff. But once you have emancipation, then that manumission provision doesn't matter, but they still want their stuff and somehow know that it is in the will and that they should sue for it. And overwhelmingly, they win.
Those are really interesting. Is there, so can you give us sort of one family or one?
Sure. So the Haley family in North Carolina, Holiday Haley, that's his name, was the enslaver, and his brother is the executor of the estate, and there's no wife or legitimate children. And he has left all of this, his or at least most of his estate, to this named group of formerly enslaved people who take the last name Haley and then demonstrate to the court that they are the illegitimate children of the will writer. And but the executor refuses to pay them. So this suit goes on for a long time, and the lawyer's brief talks about, we've asked nicely repeatedly for what we are owed, right? For what has been promised. And the court in North Carolina will ultimately say, yeah, the intent is really clear. There is a willingness to pay this stuff of value to these named individuals. And they have a right to own it. And it doesn't matter how they became free, whether it was through the provision in the will or through emancipation, they are entitled to that bequest. That is theirs now. And I think about that generationally, and I can see myself going down the rabbit hole of tracing family lines, which I never thought I would do. I'm going to become a genealogist, and I want to know who owns that land. I know exactly where that land is. I can identify it, right? It's like next to this tree around the corner, you know, the way that 19th century wills describe it. But I can identify this plot. I want to know who owns it, and I want to know what happened to the descendants of the Haley children who acquired that property, and what their lives over time have looked like compared to those who were, say, sharecroppers in the same county.
And, you know, I think something that, and I didn't really realize this as you were working on the book, but that something that you and I share an interest in is this question of private law or civil law, you know, all the things that for most of us, It's the kind of things that are like, did you make a will, or did you make a contract to do something? It's those kind of everyday, annoying kind of legal things that you have to deal with at some point, perhaps in life. But you're pointing out that these are really the things that slavery in some ways is built, the legal structure of slavery is built on, is this private law. And it's important to think about it's called private law or civil law, but it's called private law because it often involves relationships between, it doesn't even have to be citizens, right? Just between two persons under a jurisdiction or whatever. And I think that for me was one of the big contributions for the book, is to help us to think in those terms, because we're often quite, either aware of the larger constitutional context around this, right? But shifting our focus to those really local, everyday, not local because you're dealing with state appellate cases, but they're coming out of local and private circumstances. And I think maybe that, to come back to the comments that you made at the beginning, to think about your relationship with the modern abolition movement, because as you point out, and maybe I'll just fill in some of this a little bit, today when we think about the abolition movement today, the modern abolition movement, we think a lot about, Ava DuVernay's film, 13th, right? We think about the 13th Amendment and its notorious exception to its abolition of slavery and involuntary servitude, right? It abolishes slavery and involuntary servitude, except, right? And it's, as an English professor, that exception, and I'll read you the exception in a moment, but it's wedged into the middle of that sentence, right? It's that sentence, abolishing slavery and involuntary servitude, straddles grammatically, syntactically, this exception, right? So that you kind of can't even think about this without saying, except as a punishment for crime whereof the party shall have been duly convicted. And so in that exception, a lot of scholars today, and not just scholars, activists, critics, see, and I think rightly so, policing and mass incarceration as an afterlife of slavery, right? To use the term that Saidiya Hartman got from Stephen Best. And so, I want to come back to this and think about how does your work, because you're not focusing on the criminal public law, both criminal law and constitutional law are all part of what we call public law, right? But you're interested in the private stuff, the stuff that's between individuals, between families, right? Corporations, all those businesses, right? That's the stuff of private law. Those are the subjects of private law. And so I'm wondering how your work can maybe complicate or enrich our thinking about today's abolitionist movement.
I mean, that's the hardest question. That's the part where, you hope you stick the landing on that one. But so historians, legal historians of the 13th Amendment point this out repeatedly, that the except as punishment for a crime part, standard language, comes from the Northwest Ordinances, not at all controversial in the moment, that a couple of radicals are like, that's maybe a little not good. Maybe we should think about that. But this was not a controversial thing. That aspect of the 13th Amendment was not the big hurdle. It was about emancipation and then how much bigger the amendment was going to be. And there were early iterations, drafts of the amendment that included citizenship and that were much, much more substantial than a very short text that ultimately was ratified. But that was not seen as particularly unusual or odd at all. It became this mechanism for re-enslavement, or a form of getting at control over African American people in the absence of slavery. And that is the sort of quest of the post-slavery South, not just the South, but particularly this sort of redemption era. So right after the radicals sort of lose control during Reconstruction, it's sort of like, okay, so how do we rebuild this society, this Southern society, along the same lines and in the same image of slavery, right, of the antebellum past? And, well, okay, we'll just transfer the power that the masters used to have and plant it firmly with the state. And the state will regulate the movement, the employment, the legitimacy, the citizenship of Black Americans. And, well, you know, if we charge them with crimes, right, then we can take that regulation to its, you know, furthest conclusion, right, into this carceral system, which was generating, and at a certain point, 3/4 of some southern states' revenue. Like, I mean, I give these statistics. I can't rattle them off exactly, but I think it's Tennessee, where it's close to 3/4 of their state budget comes from convict leasing at a certain point. So this is not an arbitrary or insignificant amount of money that the state is able to generate off of using convict labor, right, which is a form of slave labor.
Just specifically, like to work in brick factories or to build railroads or things.
The turpentine factories were the worst, right? But anything that you could be hired out to do, roads, bridges, infrastructure projects, anything that you could get a company to hire a population of prisoners to do. But that's the obvious places, right? That's really visible. That we can see really clearly. And I think scholars have, especially in the last 10 years, really brought that forward, right? You're saying, you know, 13th, all of these other things that, oh, well, this is how this carceral state, the apparatus, policing apparatus became central to controlling non-white people and sort of scooping up non-white people into the web of the state. It's much messier when you're looking at relationships between individuals. It's much messier if you think about contracts and the way that contracts would then be used for sharecropping arrangements and other unequal kinds of agreements, where the assumption is that, there's still value in an enslaved contract, right? I mean, it's I suppose the part for me is, I think about abolition, building off of Du Bois, I think about abolition as requiring two things. You have to remove the legacies of slavery, those little pieces that are left, the things that aren't just that property relationship, that aren't just enslavement. And then you have to build something different in their place. And in private law, neither has happened. In criminal law, well, you've built something else. It's just still based on these older assumptions. But in private law, there was effectively no removal. There was no sort of clean slate. There was no sort of commitment to the most radical of judicial views, which is, if you mean that slavery is over, you have to get rid of all of the things that are related to slavery. All those agreements, all of the assumptions about legitimacy, all of these things have to go, or else you're leaving pieces of it in place. What would happen if you traced families who were deemed illegitimate? This keeps me up at night, actually. I think about this, and maybe this is part of the second project. What happened to all of the families who were deemed illegitimate and therefore unable to inherit? What happened to them? And what claim could they make now as a consequence of that? I mean, it would be hard to make in terms of, a statute, but it would be splashy publicly, right? Of all of these decisions, rulings that affected Black family life based on assumptions and laws and rules that came out of slavery that shaped generations.
So for you, that would change the sort of the way we think about reparations, all of that.
Right, and about, for abolition to happen, you have to look in these little corners, these places that you don't think slavery is lurking, because it's everywhere. As you said, all of American law is built with slavery's existence there. It's not as if just saying, well, now people can't be property is going to fix it, because it was so much more. I mean, one of the questions that actually judges were asking is, well, are the laws of slavery still applicable? Like, do we still use these statutes in criminal cases? Because maybe not, or like where does the formerly enslaved person fit? Like, do we treat them like, do we use the statute for black person? Because that's different from the statute for white people in the South at that time. Can we still use the statutes that are written for enslaved people? Like, that was actually a real question. They weren't sure whether they should do that. That's not abolition. That's not even thinking in terms of like, oh, this is done. This is an institution that is fully collapsed.
No, I think that's incredibly helpful to think through this all. So I hope it's a really rich book. So I hope people will think about reading it for themselves.
Don't read the contract chapter.
I love the contract chapter, but I think there's a lot there. Hopefully we've touched some of it, and I'm sure people can follow up with some questions that will further elucidate. I realized as we were talking, there's a little bit of a tricky thing, which is Giuliana and I have been talking about these things for a long time, and we've been it might be a little bit of twin language. So hopefully people's questions can help elucidate things that we haven't made clear ourselves.
Thanks.
Okay. I never like being the first question, but that's okay. Thank you. I'm really excited to actually get my hands on the book and hopefully a print copy that I definitely won't pirate because I want you to actually make money off of this. Something that I'm thinking about is just, especially right now with all of the news about the Supreme Court and kind of a lot of questions about, what courts can do. And I realize that's more public law is my understanding, but kind of how do you consider the court and the law like a historical actor in your work? And just, I'm not quite sure on your periodization because I haven't read the book yet, but, where does, especially for us non-legal historians, where does that happen?
That's a great question. One of the things that I've sort of taken away from this project is just how arbitrary our law is. It's down to a vote here, or a vote there, or this kind of judge here, or the one that was sent down from Massachusetts to Mississippi. And so he's going to do some very different things than the folks in Kentucky who, don't have to go through military Reconstruction. I think that's one of the things that is frustrating to people, certainly to students, is that you have just 9 human people making decisions about really, really big things, and just those 9 people, and that's what the law is now. And that is something that could not be hammered home more, is that these are some dudes sitting and chatting about slavery and what the law is supposed to be and making decisions. And if a different set of judges were there, would they have reached the same conclusion? I don't know. There are certainly far more radical people that could have been on those courts and weren't. That's true. Many of these judges on these appellate state Supreme Court level, they're not removed. They're there during the Confederate period. They are there during slavery. They are themselves former enslavers. They are fully embedded within slaves, this slave society and within the economy of slavery. Sometimes it's their contracts, right? They're also invested in the outcome of the ruling. Will they get paid or not? So, the arbitrary nature of a few people deciding something that big is kind of horrifying, and yet that is how the law is made in our system. There are statutes there and there's constitutional amendments there, but what those this is why you and I have talked about this. So originalism is not real. It is not a thing. It cannot be identified. If that were the case, the 14th Amendment would be interpreted very differently. But they're deciding, right? It is the interpretation of judges who are deciding what those things mean. Whatever the framers intended for it is as a moment, right? That is perhaps, we might have debates about, or congressional records. We can say, okay, Congressperson X or Y said this or that, but it's the judges who give the thing meaning ultimately. And so I read these law review articles written by people who are desperate to see the 13th Amendment used in this very different way, where what it means to abolish or what it means to end slavery is much, much bigger. And if only we could get judges to just think about it that way, we could use the 13th Amendment today in a really powerful way. Whereas other abolitionists say, don't bother. It is corrupt and broken beyond, right? Because of this phrase, right? Forget it. It's useless. It's useless to us. But this quest to recover its original meaning, and I was like, but it was never given that meaning in practice, because that's not how judges decided to use it.
Was there any possibility that the Freedmen's Bureau outfits could have performed a function of informal dispute resolution, like the Allen case was between members of a family, and would they perhaps have been better served by turning to an alternate decision group?
So the Freedmen's Bureau, could the Freedmen's Bureau have really negotiated? They did in many cases. Most disputes between members of freed families did not come before a state Supreme Court. These are, by their very nature, exceptional, which pluses and minuses for that. I really had to think about whether that was, as a source base, the way I wanted to go, and I came down on my answer. But the Freedmen's Bureau did adjudicate a lot of different disputes, especially among family members, but they were not necessarily going to think about the questions in the same way. So, for example, there were often people who had multiple living spouses, right? Where forced separation meant that you might have other spouses and other children in other places, and maybe you wanted to reunite with a different spouse and not be married to the one that you were most recently in a relationship with. So the Freedmen's Bureau would adjudicate those sorts of cases, often in terms of just sort of very pragmatic things like, well, which wife had the youngest children or the most number of children that would need a male head of household to support them? They're not necessarily involved in thinking about, well, what does this mean in terms of citizenship? They're interested in, what does this mean in terms of the people right here on the ground who have immediate needs today? But also the Freedmen's Bureau, as we know, is not particularly well funded, and they're not able to get to everybody. Most people are going to work this out on their own, and it's going to be whatever individuals come up with as a solution. Again, for these folks to get to court is I think itself exceptional. People ask me all the time, well, how did they get the money? How did they get the money, and where did they get the lawyers? And the answer is, I don't know. I've tried to find that out. And sometimes the Freedmen's Bureau will pay some money, or sometimes the case will come from the Freedmen's Bureau and be taken up by a lawyer who's willing to do that kind of advocacy. But I don't know where they get the money. I have never been able to trace it, but I bet you could. I have tried to find this in some places, but, well, there's two things. One, I don't see repeats in the state, right? So I don't see, Jones and Jones again and again and again. So, because I thought about that, if I could identify a lawyer who consistently appeared, then I had a foothold. I couldn't find that, and oftentimes the names are very common, right? So there's not a distinguishing name that would help me find something in a census record or anything like that. Or I can't read them at all because it's scribbled. And sometimes the names aren't complete. I might have a piece of a name, but not the whole thing. This is another one of those things where I could very easily go down the rabbit hole because I really want to know who these folks are, and I don't think they're Black lawyers, and I don't think that they are Northern attorneys who come down. Although I think there is some of that, but I don't think it's exclusively that. I think they're probably working, hoping to get a piece of whatever they win, which, if you are suing for inheritance that is, this tract of land and $2,000, you might get a percentage of that. Then you'll take the case. But you're going to get nothing if it's a case about custody, right? Or whether or not this marriage is actually considered bigamy because you didn't get a formal divorce from the first wife that you were married to, on the plantation, and then you got married to somebody different after emancipation. There's nothing to be gained there. So I don't know. I wish I knew.
Hello. Hi. Oh, okay. Thank you so much for this one lovely conversation. I think just in the 30 minutes that you were conversing, I had so much to think about and so many different points in which I felt inspired and also excited about the potentials of this book. And so actually this is a build off of Emma's question, so I apologize for backtracking the conversation just slightly. But I was thinking a lot about kind of the tricky tasks that comes with untangling our understandings of whether that be litigation or definitions, right? Giuliana, you started off with this framework to say that there's a difference between enslavement and slavery, right? And how in this work, which I haven't read but am very excited to read, you untangle those things, and then also particularly around the 13th Amendment and the kind of notion of the exception that comes along with it. And so all of this conversation got me to think a little bit about, say, the co-opting of a lot of these terms by various political parties that has been pretty prevalent, I would say, in the past 2 to 3 years, right? So particularly when you were talking about reparations, right? Supporters of reparations can be for racial justice, right? But supporters of reparations can also be from the other side to say, oh, Black people, now it's time for you to stop complaining after we pay you out, right? And the same goes with abolition as well. So I'm wondering, Giuliana, especially as you've published this book and now have put yourself into this conversation, how are you planning, or how do you envision grappling with this? And particularly, what advice to us graduate students that also do work on racial justice? How do we navigate that space?
I think about this a lot. It's a really good question and a difficult one. I think that things like abolition or racial justice don't actually have an endpoint, at least not one that I could imagine. There is a process, there is a project, and the terms of that project will be defined by those for whom that project is most deeply personal. And the job, as I see it, is to think through these really messy elements that are so difficult to disentangle and that are so difficult to tease apart, to make visible things that aren't immediately obvious. I can say, especially with, well, what are reparations and how might they be used? I've been reading a lot in this area recently, and it's, take the new plan in San Francisco, right? There's a proposal for reparations in San Francisco. The sticking points are just legion, right? well, how do you determine who's eligible? Or should it be money? Or should it be, and should those funds be controlled? Or. And that's only on one side of the debate, right? So I think that it's imagining that this is not a project that you will see finished, but one that you're still willing to participate in and a fight you're still willing to have, in whatever terms that looks like for you as a scholar. My story I didn't see in the scholarship, and I hoped that it would be instructive and helpful to point out a different space, a different legal landscape for abolitionist action or attention. I don't know whether those who are, especially the lawyers, right, who work in this area, whether they will take that up or not. So I guess success is not, I mean, I don't know how to measure whether or not it's successful in that regard, but I knew that it was a story that needed to be told, because looking only in the criminal justice system is not going to get you. It's only part of the story. I wanted to show a different track, a different place for activism, even if I'm not the one in the courtroom doing the litigating or making the arguments. I could at least arm somebody with information they didn't already have. So I think for me, that's how I think about it as an ongoing project that you contribute to in the way that you can, as you can, or else you'll lose your mind.
Just staying in the presentist register for a minute, because you began by encouraging or sort of claiming your commitment to making connections and with sort of the living legacies of slavery and the present. So how does your research influence, and how can you, based on your historical research, articulate your understanding of anti-critical race theory today? Like, what do you see, and what can you help us to understand, given your historical perspective?
All right, I'm going to be a real historian. I'm going to start with a story. So a year ago, winter, I was teaching the U.S. History Survey, as I often do in the winter, of 1820 to 1920. And every year we do section visits, and I went to a section, and the TA, it was Ida B. Wells was the assigned reading, the Red Record, which is about lynching and racial violence, that was written at the turn of the century, so we're 1895-ish, I think. And the TA asked, well, how many of you think Professor Perrone is teaching critical race theory? Every single student in that section raised their hand. I was not teaching critical race theory. This is not a law school. You are freshmen. But I got to teach them what it was. I got to give them, I think I used a New Yorker article about Derek Bell and sort of the impetus behind critical race theory and what the sort of central question was, which is, how can we be this far out from the decision in Brown versus the Board of Education and still be so far away from equality and where we had hoped this decision would lead us? And he is a lawyer. This is talking about race is not critical race theory. Thinking about the implications of the existence and evolution of race and changing definitions of race and what it means to be white or not white and who gets to be in one category or another, that's not critical race theory. And it was an instructive moment for me to hear that all the students thought I was doing this. And so the next time I was teaching, I just gave them the article to start with, so that they just knew right off the bat I was not doing this. But even if I were, that wouldn't be a bad thing. I would be asking them to engage with one approach to understanding the past or the present, right? Or we could understand it, critical race theory, as a product of a particular moment. We could understand it as a theoretical framework. We could understand it as practice, because for some lawyers it is. And none of those things involve me sort of dictating to them what to believe about race.
Structures and codes that generate and perpetuate inequity. Critical race theory is about institutional structures, Professor Perrone.
Which means it's not about you. Right. And it's not about you feeling bad about yourself or your own, right? But critical race theory, so the parents are all like, they're going to make my white children feel bad about themselves.
That's anti-critical race theory.
Yeah, right.
Yeah,
right.
Anti.
Right.
So my question is, how do you address anti-critical race theory from your
I mean, I usually approach every class with the same sort of opening, which is history is an evidence-based discipline. My job is to teach you how to evaluate evidence, and every lecture I give or lesson I teach is based on the evidence that either I myself have collected and analyzed, or that my fellow historians, using the same methods that I have been trained in, have used, that we have collectively assessed, and I'm giving you the best of the best, right? Where we are as a profession. And if you want to come and debate on the evidence, let's debate on the evidence. Yeah, I mean.
I also think having seen for you before.
Yes.
Your metric for failure in the class is, hostile knowledge, which I also have found to be a useful teaching tool and tool for life.
Right. That is my metric for an F grade. Is this hostile to knowledge, or are you actually considering something with real thought? Hostile to knowledge is yeah. I learned that from a professor who is the kindest human being ever, but I thought this was perfect. Is this hostile to knowledge? Are you against the very notion of thinking or learning? So what I'm asking, what I constantly try to do is root what we're doing in the methods of the discipline, and what I am saying because this evidence suggests that it is the best way to explain what it is I'm teaching. Sometimes it works, sometimes it doesn't.
So my question has to do with a comparative framework and the whole field of transitional justice, which is basically what this is. But what I've been thinking about the whole time is how comparable this is to my own work on post-Nazi Germany. Germany has a long legal tradition, lots of, tenets, the great legal scholars and such like. And so they had to deal with the same problem. All of a sudden you declare Nazism and Nazis not non-existent, but they're removed from citizenship. So you have this denazification process whereby they can go back. And so what triggered my thoughts are, we talk about reparations, but the Germans have gone into this much more deeply, and they use 3 different terms. Reparations is to repair damage done. There's compensation, which is to pay for work performed. So if you were a slave laborer for Continental Tires and you worked this many hours, you're entitled to compensation for that work done. And then the third one is restitution, to restore. So if property were taken away from you or you were forced to sell it, that property had a certain value. Paintings, it's been in the news. So they have these 3 different terms: to repair, to restore, and to compensate. And they're very different, and they apply in different ways to some of these same issues. But just the cases that the Germans went through and the power relations of these judges, within 8 years after the end of the war, so by the early 1950, 1953, 77% of the Bavarian judiciary were former Nazis. And they would rule the same way as these white judges that you're talking about. There are cases, celebrity cases. We all know about Adolf Hitler, who was quite rich in property and all kinds of stuff. He marries a young woman right before they both commit suicide. It's a legal marriage. And what happens to all his stuff? You can't denazify the dead, so it actually goes to Eva Braun's parents. So there's a denazification trial of who gets Hitler's stuff. And the Allies basically say, forget it, Germans, you can't do this. But then stuff comes up after occupation is over and the military is no longer in control of the judiciary, and they do get awarded some of the stuff that hasn't been otherwise disposed of. So there's just all these bizarre legal twists and turns, and it basically goes through a couple of generations, and now we're still paying compensation. We're still getting companies to fund various compensation and reparations claims. There aren't that many people left alive to give them to, but so my question is ultimately, have you thought about this comparative context? So not just, Germany is far away, but there are a lot of countries that abolished slavery and how they handled similar things?
I have thought about it a little bit. One of the things that is particularly interesting to me is the way that Nazi law was sort of universally invalidated in a way that does not happen, right? There is no, there's like this, for a hot minute, occupation of the South, but there is not actually Reconstruction in the sort of fullest meaning of the word. It's a very quick return to a sort of status quo ante, right? There's not a sustained, there's no ability to have a sustained Reconstruction effort. And the chronology also makes things challenging. So you mentioned, there aren't that many people left. So the question in reparations, one of the questions in reparations debates now is, do you have to be descended from enslaved people in order to be eligible for reparations? My answer to that is categorically no. I don't think, if you have been ensnared by the racism engendered by slavery, then that seems good enough to me. I went to this conference on reparations and one of the presenters, an economist, was trying to model how you would identify descendants of enslaved people in the United States using some kind of, it was a lot of math, I didn't know, but using genealogical records, modeling something specific so that you could come up with numbers and then an amount, right? Based on those numbers, or at least be able to identify. And her conclusion was, this is a lot harder than I thought it would be. Literally, that was the conclusion. She wrote that out in the paper. This was way more difficult than I could have imagined because census records are not super great. But also because the sheer number was so huge that she just used two sets of census records, and the number was sort of more massive than she could really make sense of. So that's one of the comparative problems, is that this has been an issue from my perspective, right, and I think many people here, an issue that has been unaddressed for so many generations. How do you identify, the easy part is I can use legal records or property records and say, okay, here's the property that was taken. Here's the property that wasn't inherited or that was taken through heirs property actions or different mechanisms to basically steal land from, formerly enslaved people. But the people who own it now had nothing to do with that. They bought it through a legal process from, somebody who bought it from somebody else, right? So the generational change in ownership might be such that whoever owns it in the moment has nothing to do. Might be a retiree from Boston living, in the South because it's warm. So there's the condo on the coast of the Atlantic coast that used to be swampy rice lands that black families lived in near the Sea Islands that have been turned into condos, right? The person that owns that condo or the developer of that condo had nothing to do with the theft of the land to begin with. So then who caused the harm and who pays for the harm? Right. But it was clear. That's just it, right? If you go through legal mechanisms to take land, right? If it's the heir's property is particularly nasty, but it could just be eminent domain, right? The Bruce's Beach case, which we're more familiar with here, can be traced to one specific family, right? And that was a municipality that did the theft, right? That we can say this city government is responsible for this illegal taking. But for most of the properties, that's not the case. It was legally taken, but taken nonetheless. And that we would not consider, through all kinds of nasty things, but that were perfectly legal at the time. So how do you account for that? The other comparative one is Britain, right? They paid slave owners. That's how they got around the problem of uncompensation, So I have a friend who's writing a book about reparations in their original term, which was to pay former slaveholders for their lost slave property. That's the original use of reparations, at least in this story. And Great Britain got around that problem of illegal taking of property without compensation by paying enslavers for any lost property, which they were still doing until very recently.
And they used taxpayer money.
Yes, they did. That's right. There are a lot of very wealthy people who were compensated. Most famously, Benedict Cumberbatch's family received money this way, and not an insignificant amount of money, right? So what do you do with that? Because the legal claim was taken care of, right? The specific legal problem that could be identified at the time of slavery's end was addressed. I think King Charles has this problem because more and more of the Commonwealth is not so interested in sticking around without reparations, right? The former holdings of the crown are demanding reparations, and some of the legislatures are demanding restitution and are saying, look at the state of our economies, look at the poverty of our people. That is because of you. That is because of empire. That is because of slavery, and you are required to make us whole, right? It's a very kind of simple claim of harm with big implications.